we move to video number 5, sir, and I look forward to your views, sir, and your guidance as you would like to sort of bring out. Now, presently everyone agrees that Supreme Court has been inundated with the routine petitions under Article 136, and that leaves very little time with the court to decide important constitutional issues. Sir, as a way out, what do you think? Is a case made out for establishment of a separate constitutional court and a separate court of appeal, or is there any other way out?
No, I don't favor that. I like the Supreme Court as it is. I like the Supreme Court in the way it functions. In fact, there should almost perpetually be a constitution bench of 5 judges designated throughout the year.
Okay.
In
standing court.
Standing court. The bench, the composition may change. Yes. There may be different judges occupying that position, but there has to be an opportunity for the court at any given time during a year to decide a particular case of constitutional importance.
Right.
You see, the absence of a constitution bench, a regular constitution bench, leads to this, that, oh, Kashmir issue is not yet decided, for instance. Yes. I mean, just to take one.
370 is still not decided, yes.
No, that removal of 370, everybody was worried about it. May be right, may be wrong,
yes.
but at least let's have a decision on it. Yes. There's no doubt about it.
Sir.
Therefore, the way out to my mind is that the Supreme Court already has now 35 judges or 36 judges, and therefore time enough to deal with each one of them, and time enough to have a permanent, a sort of a semi-permanent constitution bench, yes, consisting of different judges at different times, but always there, yes, to decide any constitution bench matter, because a constitution bench means a bench of 5 judges. Now, there are special leave petitions which take up a lot of time for the court. Now, one way out was and still is one solution perhaps is that there is a provision in the Constitution that judges who retire are also can be taken up as ad hoc judges, yes, and added to the strength of the court, and that doesn't affect the regular strength of
composition and strength. Yes.
So you can have another set of 5 or 7 or 9 judges outside the normal strength of 30 of, yes, the full strength of ad hoc, yes, judges, who could look after and consider from day to day the proliferation of work, yes, in this form of appeals, special leave petition. But because remember that 136 is a very important provision of the Constitution. Yes. I wouldn't tinker with it at all. I wouldn't affect it at all, because you never know at what point injustice, yes, may be there, because there must be some injustice. Yes. There must be some injustice, not merely questions of law. Yes. There must be some injustice, yes, that has to be rectified, and that is the most effective remedy of injustices. I place great reliance on 136. It is a searchlight provision. It's a searchlight provision of the Constitution, yes, which looks into even small matters, yes, which sometimes escapes scrutiny of the court. Yes. And therefore, I would say that in addition to the normal strength of the court, which is already,
yes, make use of these additional, yes,
which if you remember, the original strength of the court was 7 judges plus 1 Chief, yes, Justice, and now it is 34 plus 1 Chief Justice, which is 35. So
substantial increase.
Can be more. Yes. The regular strength can be more or less, whatever it is. But there must be a set of ad hoc judges who will then decide this extra burden that come on, namely 136, which takes up so much time of, yes, the court.
There is another matter relating to very interesting aspect you had brought out in the book State of the Nation, and I am referring to page 376-77, relating to institutional memory. And you narrated an incident where an outgoing Chief Justice of India had decided matters relating to what they were then called Vanaspati group, and it was brought to the notice of the new Chief Justice, and the new Chief Justice along with 3 senior judges, they decided to recall that matter and review that, and they then rectified what in their wisdom ought to have been done by the previous person. And you have said that this sort of a thing does not happen, may happen when required because of not having institutional memory.
Yeah, the need for an institutional memory is really a polite phrase for saying that when something has monstrously gone wrong, apparently gone wrong, as it did in that case. Chief Justice Kanya, not the original Chief Justice of the High Court, but the Chief Justice, his nephew, who was a judge of the Bombay High Court, who was later in the Supreme Court, had this solution, namely that when a particular matter was argued, the Vanaspati group matters, and in the background in which it was argued, before a particular Chief Justice, etc., and the demission of office of that Chief Justice, who had a very short tenure, the question was what should be done, because this was something which was rather monstrous, that what had happened. And the solution that was found was a most statesman-like solution, one of the best I've ever seen.
A good innovation in a way.
Innovation, which was that institutional memory is a nice phrase to use to cover up a lot.
But how can this institutional memory be instituted?
No, it can only be sparked.
Perhaps some very senior advocates, they may sort of by way of a thing remind. Sir, my last question to you would be that presently a large part of the country has witnessed this very unprecedented situation of these wrestlers, women wrestlers. Now, for of course, this matter has really not come up to the trial stage so far.
No.
But
we don't know who's right, who's wrong.
It cannot be commented. But for a thing like this to happen, itself is not very sort of doesn't appear to be healthy.
No, I agree. You see, this only is a fractured state. You see, we find this fractured state of, because everything that the government at the you see, this has repeatedly happened. It's very unfortunate, and it has only because of the intolerance of the majority party in power. Yes. It has happened in the Congress regime for many more years than in the BJP regime. Many more years, the same sort of thing has happened constantly. Namely, that you just cannot see in a particular state with a form of government which is allied to a different political party than the one from the center. It is very unfortunate. In fact, you see, that is the whole purpose of a democracy. If you see Jennings' book on cabinet government, Ivor Jennings, he says that in England, the opposition is not called the opposition. It's called His Majesty's opposition. And the importance of the word His Majesty means that it is part of the structure of our English constitution that you must have an opposition. Not
government, government in waiting.
Government in waiting. That's the whole point. That's the whole point. Therefore, you must elevate it to a certain. Whereas we don't elevate it. Neither the Congress did it during its long tenure, nor in its slightly less long but still long tenure, the BJP doesn't want to do it. It just can't see that there can be an opposition. There has to be one party state. No, that democracy will never work in a one party state.
Hopefully hopefully this realization will dawn upon at some stage.
I hope it dawns upon.
Thank you very much, and for the time that you have given, and I am sure that years and generations.
I think Justice Karnan
Justice Karnan.
Justice Kannan, I will do that, sir. Thank you, sir. So thank you very much, sir. And the law professionals, law students, all judges would benefit from your wisdom. Thank you very much, sir.
Thank you. Good to see you again, Mr. General. I've known you for many years.